Thank you for joining us for today's webinar episode, Handling the Arbitration. Okay, my name is Jeff Zano, as is mentioned. I'm your moderator today, honored to be the moderator. This webinar is part of the Financial Poise Alternative Dispute Resolution webinar series. And on slide 7, I'll turn to it for you. This describes a summary of the series. This is the number 4 in a series of 4. Slide number 9 summarizes this episode. Okay. And speaking of the slides, you should understand from the get-go that we may not step through all the PowerPoint in order, nor will we have you listen to us read any of the slides. This webinar is like all Financial Poise webinars. It's a conversation. That's what we want to have today. Keep the PowerPoint handy, though, however, because I will try to indicate from time to time what slides our conversation is touching on as we proceed, so you can take notes. Slide number 4 has our disclaimer right here. Okay. Please note that our PowerPoint is for informational purposes. It should not be considered legal, financial, or other professional advice. Okay, now I have the honor of introducing our esteemed panelists. We actually have 3 today, but one's running late. I'm sure she'll join us shortly. But we have, first of all, Leslie Burkhoff of Mort, Hock, and Hamroff, LLP, in New York. Leslie is a partner with the firm where she serves as chair of the firm's dispute resolution practice group and is the former co-chair of the firm's creditors' rights and restructuring department. Also joining us today in the panel, and she'll be coming shortly, is Liz Champenoy of Champenoy Dispute Resolution and Management Services, Inc. Liz is an attorney, consulting expert, independent full mediator, arbitrator, and trainer based in New York City with 25 years of experience in the field of ADR. And then we have finally Byung-Suk Seo of Snell and Wilmer of Denver. Byung-Suk is a business litigator who represents individual clients in complex intellectual property and commercial matters, and as clients have sought his guidance in disputes related to failed business ventures and disputes among business partners, shareholders, and directors. And again, my name is Jeff Zano, and I'm the vice president of the commercial division of the American Arbitration Association based in New York City. Okay, so feel free to read more about the panelists, our esteemed panelists, on slides 33 through 37. Again, slides 33 through 37. This webinar is a production of Financial Poise. To sign up for their weekly, their great free weekly newsletter, go to financialpoise.com/subscribe. Again, financialpoise.com/subscribe. If you are attending the live premiere of this webinar today, you can submit questions using your web portal. If you are watching this on demand or have any questions after the webinar, you can send an email to any of us, but also to Financial Poise at info@financialpoise.com. Again, info@financialpoise.com. Just include your questions in the name of the webinar episodes, and we'll do our best to get you an answer as soon as possible. Okay, we'd like to thank our co-producer, the National Review, a premier legal website. The National Law Review has been around since 1888. And I'll just quickly show you their slide. All righty. Okay, well, let's get started. I will turn to the first slide on handling the arbitration. And we're going to go through 3 areas today. One is motion practice and hearings. The next is post-hearing submissions. And then finally, award issues. So with that, I will first turn to Leslie on case-specific rules and procedures that exist out there.
Okay, so thank you, Jeff. It's really important to recognize, really no differently than when you do a litigation, that there are different rules that are going to govern different types of arbitrations here. I think sometimes people forget, and the type of case and the rules that apply generally are dictated as follows. When you file your claim with AAA or whichever entity it is, you're going to designate initially where your demand is. So is it a consumer case? Is it a large complex case, etc.? Sometimes they're modified based upon the institution itself. So, dollar amounts may kick you into different buckets. One of the other things, though, may be is that even though you think it's an X dispute, if your underlying agreement says that the certain rules will apply, so every now and then you could have what is really a consumer dispute, and it's going to be filed in the consumer, department, if you would, of the AAA. if your underlying agreement says commercial rules are applying, you sort of have a, a square peg, round hole. So, on the front end drafting, it would be helpful. Some of them are designed like expedited and fast track or to move things quickly. They usually do away with things like some of the discovery. The documents only case tends to come up also sometimes in consumer, but also sometimes in commercial financial. And what it'll be is that they don't want a hearing. They basically, it's almost as if it's a summary judgment, although you're not applying a summary judgment standard because the decision is going to be made based upon the evidence that is submitted to the arbitrator. And it's as if they brief it and submit documents because there's no such thing as a default judgment in arbitration. So if somebody files a claim and nobody responds, unless the claim came along with a client attestation and supporting evidentiary documents, an arbitrator cannot make a decision just because you said it was a breach of contract. We need substantive evidence in some form before us.
And Leslie, I can't stress enough that you got to, in the arbitration clause, be more specific about the rules. It drives us crazy, all of us on this call. And we have an intake department at my company. I know the other institutions do too, and we try to figure it out. But it makes sure you put the rules in there. That's really, really important.
And just for one other second, if I can, please recognize it's always the parties' process. So notwithstanding what an agreement might have said at the outset, if both parties are in agreement that, you know what, I know it said the commercial rules, but we've decided it's now it morphed into a construction dispute and we're good with those rules, no one is going to stand in your way. But it also should go into when you meet with your case manager to pick an arbitrator. Because if you think it's a construction or a labor and employment, you better make sure you have an arbitrator with that experience.
Great point. And if I can make one more point on the expedited and fast track, be realistic. If you're going to put that in your clause and it's a multi-million-dollar case and you're saying it has to be expedited, it's not realistic. So just be careful about that kind of stuff. So beyond so, information exchange and preparation. I'll turn to you.
Yeah, you bet. This slide really addresses that time period after your preliminary injunction hearing and before the hearing evidentiary part really starts. And that's where you're working up your case, essentially, to use a litigation phrase. So you want to exchange information and prepare for the hearing. And unless there's some explicit agreement and you to do otherwise, you try to avoid the typical discovery stuff or the full breadth of the discovery kind of tools. And for the non-litigators out there, discovery is basically that phase between case initiation and right before trial, where you try to learn as much facts as you can through written discovery, interrogatories, requests for admissions, or documents, requests for documents or depositions. And you can do subpoenas and such. So that's where you not only exchange information voluntarily, which I encourage everyone to do, the cheaper it'll be to disclose as much information as you think the other side will want, as well as that supports your case, the easier and more affordable this phase of arbitration will be. Then you basically try to also assess, hey, what depositions do I need, if at all, to prepare for arbitration? Now, just know our depositions are costs. So the more deposition, the more costs that you incur, not only with attorney's fees, but the cost of travel, if the deposition has to take place elsewhere, because there's laws on how far a witness is forced to travel to be deposed. And the other factor that most likely parties, but their attorneys consider and think about is, do we need expert testimony? And if we do, that's another way to develop information. And a lot of sophisticated cases will require some expert testimony, at least on the damages, if not both liability and damages issue. And then once you do that, you identify the documents and the witnesses you want to prepare, and you work them up and get ready for the hearing.
So
Beyonce, I have a quick question. It says the arbitrator addresses any issues or objections related to information sharing. How often does that happen in your cases? Or it depends, I guess.
Yeah, it depends, but I would say in my cases where I have not seen a well-drafted arbitration provision, it happens more than not. Because I typically run into a situation where one or all parties are not comfortable with doing anything other than what they know through trial. So you get a lot of motions practice and you're sitting there going, do we really want motions practice? Let's just get to hearing faster, because you're going to pay for the arbitrator's time. Unlike
Sure.
unlike in trial in trial courts, our taxes are paying the judge's salary. So you file a significant motion, you may not see an increase in fees from the judge, but from the arbitrator you do. So really think about, okay, is it worth all the effort for my attorney and me paying half the arbitrator's time to file a motion, when in actuality we could just fight it out at the hearing and let it all fly in. So typically, to answer your question, Jeff, the issues that I typically run into is just if I think the disclosures are not adequate and I can't reach an agreement with the opposing counsel to say, hey, you promised to get me these things and you only got A through P when you're missing, the rest of the alphabet of the information that you promised me. And that's what I like about arbitration is typically they're more open to, let's just have a phone call and I'll rule right away. And that's kind of nice. But again, if the rules are set out well in the arbitration provision, or at least citing to the rules you're supposed to follow, I've run into these issues less. It's when it's kind of blank that I run into a lot of issues.
Sure. Well, Leslie, you wearing your arbitrator hat, I know you're a litigator advocate, but also an arbitrator. Do you see a lot? Are you asked to address these issues a lot?
So let me add a couple of things. I'll go backwards. I'm going to take the most recent point first, and then I just want to add something. And I think people have made tons of great points, and I sort of echo all of them. The way I deal with discovery disputes is in my preliminary hearing order. I tell the parties that if there is a dispute, I want them to get me a letter. If they can make it a joint letter, great, an email, whatever. After you've done a meet and confer, so I kind of say, don't come to me if you haven't met and conferred. So I adopt a little bit of the regular. And if I can get on a call and I can resolve it without formal motion practice, that's what I'm doing. So, occasionally I may go back and say, hey, I need a case or two because I've had that once or twice, or give me a little bit more meat on the bone. But I very rarely try to have full-blown motions. I have had them. I had a large case coming up where I spent, I don't know how much time ruling on 3 different motions in limine. But there are ways that we can help mitigate the process. And Björn is right. Sometimes you have to think about it. Is the cost benefit? The other thing that I'll note is that the general rule is that evidence is going to come in different than it will in court, because we want information, and then it's the weight that we're going to give it. Okay. Now, that doesn't mean it can be completely out there with no support, no evidentiary merit or tie-in, but things that might not otherwise come in will generally come in and the rule is kind of like, if it's going to inform the process, if it's going to make me understand things, if it's going to educate me, but then I may decide based on argument what weight I give it. Peeling back for a second, just a couple of things to keep in mind. Certain of the rules, consumer by way of example, there actually isn't generally document exchanges in the true sense of document demands. Parties can talk about it and ask for it, but the general rule is reliance documents. Each year, you're going to just share your file. You're going to tell me what you're relying on, and you're giving each other that. And that's kind of embedded in the rules.
Sure.
Parties, when they wear their true litigator hats, and I had a case about a year or so ago, they insisted they wanted interrogatories. I mean, notices to admit. Notices to admit are a complete waste of time in arbitration. Don't do them. Personally, if it's not a personal injury action, even in regular state court, they are very limited, because I don't care if somebody admits something. I still want to hear the witness. So you're not getting anywhere. Okay. So don't waste your time. And interrogatories, they are a wasted tool. They have a limited purpose in real litigation. It's a bunch of nonsense. And the case that they insisted, I mean, they fought about it. And then we spent, I don't know how many hearings, how many hours dealing with what the interrogatory asked. Did they respond? Was it duplicative? Should it have been within the scope? And the thousands of dollars that got wasted for this made no sense. And the last thing I'll say is keep in mind also that in certain types of arbitration, first of all, some arbitrators won't let you take deps. International arbitration, generally no deps. It's in the rule. You can craft around it, but don't assume that deps are a given. And even if you get deps, I had somebody fight once about the fact that there would be, and it was different. It was the only witness that wouldn't have been deposed. The parties had done all their depositions. We let them be deposed per se, but normally it's only a deposition or 2. You're not deposing the world. You're just not, because it doesn't make sense. Now, size, case, complexity could vary.
Great. Well, Leslie, I'm sticking to you. We're going to go to
All right.
hearings. Hold on. I'm going to.
There we go.
There
Oops,
it is. Yep.
there we go. Okay, so a couple of things to keep in mind here. So I've already touched on the rules of evidence. That things are not going to be the same way. From a formatting perspective, by the way, it depends. So sometimes it's very traditional. It's he goes, she goes, he goes, back and forth. Sometimes the parties will exhaust the witness. So depending on the nature of the case, that witness is going once, direct, cross direct, and you're not, and then again, and that witness isn't coming back on either side. Sometimes the parties will ask, can we proffer an affidavit or a deck for direct and then do cross? The only thing is, I don't love that because I really want to hear what the witness has to say. And it's in certain limited instances for a very discreet witness, maybe it makes sense. That's one way. Sometimes for experts, the report kind of gets sort of talked about in a less traditional sort of a narrative form, and then there's crossing discussion. The other thing to keep in mind is that we get to ask questions, and we will, because if I do not understand what they are saying, unlike a court where judges don't always do that, and certainly not in front of a jury. Now, if you come to bankruptcy court, the judge is going to ask questions. But I get to ask witnesses questions because my guiding view is this. I need to understand the facts and the dispute because I have to make a decision. So if you haven't gotten it right now, there's a difference between me being an advocate. In other words, I'm not taking a witness in getting the information to get to yes, but if I don't understand something's come out of their mouth, I got to get a clarity here. I got to understand it. And the other thing is sometimes, by the way, we have an arbitration next week coming up. I don't know that the parties are getting through it. We may talk about a chess clock concept, which is you're going to whack it up evenly, and I'm going to count for time, and you're going to figure it out. Because sometimes, unfortunately, parties really don't know how to take testimony. And we're sitting there for hours going, this could have been done in an hour. We've just spent 5 hours. I don't understand what we're doing. And if you constrain them a bit, it'll change.
Absolutely. Okay, postponement of hearing. Leslie?
Okay. So here's every preliminary hearing order is going to say the dates are sacrosanct. They are what they are. Now, I will say that they end up moving at times, but they really need to move with cause, okay? Because part of arbitration is supposed to be that the process moves quickly. And what I love is the attorneys that complain about this. Oh, it took forever. It cost a fortune. Yeah, you're the people that asked for 80,000 documents and depositions and motions in limine and then postponed it 80 times. It's not always the arbitrator that's the cause of this. So with good reason, yes, but a claimant that's brought a claim has a right to be heard in an expedited fashion. And so the defendant that wants to keep dragging it out. The other problem is, unlike a court, these are hearing dates. Arbitrators are busy. Sometimes I've had to say to people, that's great, but I'm completely booked for the next 2 months. So you're not going to see me. And you want to move it. We're now in October. So again, you have to think about it. Excuse me. It has to make sense and kind of go from there.
Do you see a lot of postponement fees by arbitrators? Both of you, Beyonce and Leslie?
I do not. I typically mark the arbitrator so long as we give them advance notice, meaning we typically can tell at least 3 weeks out, oh, are we going to be able to get our act together? And I've never had too many opposing counsel fight me on the postponement I need, and vice versa. I've never, during arbitration, I've never, contested a need for an extension of time, only because one of the few exceptions to vacate an arbitration award, at least in Colorado, is if the hearing wasn't postponed when good cause was shown.
Sure.
So I don't want any chance of an arbitration hearing being overturned simply because a postponement wasn't well thought out. So I've never had that issue.
No. And then in terms of fees, at the present time, I don't have that. At some point, I do think it's a question of fairness to the arbitrator. So, someone telling me 2 months out they need to move stuff, I can refill my calendar, I can do that. But I think at some point it is very unfair because we do box ourselves out of other work. I mean, I do a variety of things, but some people box themselves out of other things. And to tell them a week before that you're suddenly moving it, look, if something awful happens, that could be reconsidered. But there's a lack of courtesy to the schedule. So I think in those instances, there's almost a fairness to say, look, you boxed me out a week of work. You
Sure.
really, and it's not a legitimate, or it's a last minute, or you just haven't gotten there. There really should be a level of compensation. So
Sure.
also the more senior and much more senior, much more, the people that are, tippy top, I'm sure they have fees.
Yeah. No, do you guys will you avoid someone that has a like really long postponement fee, like a 60-day postponement fee or whatever? Do you?
That's
Avoid those
more
people?
beyond Suck's
Yeah,
call.
Yeah, I'm remiss to admit this, but I have to. I rarely look at that issue.
Yeah, that's what I thought. That's
yeah.
what I thought.
Yeah,
And for me, if I was putting a fee in, I would probably do under 30 days.
130 days. Yeah.
Like
I mean, I've
really
seen
getting
60
close. I
days.
think 60 days is just enough time that you can recast. But
Yeah.
I think 30 and it also depends. It's a difference between a 1 day and 2 weeks of hearings.
Yes. Yeah.
Yeah.
What we do at AAA, if there's postponement fees by the arbitrators, we try to talk to them and say, hey, listen, the parties were happy, they settled. Can you cut it in half? And usually
Right.
the arbitrators agree. They go, it's just really not fair to hit them with that fee when they're all happy. Okay, Leslie, still staying with you, ex parte hearing.
Okay, so I think I touched on this before, so just for 2 seconds. First of all, if the preliminary hearing itself is getting called and the other side doesn't show up, depending on whether I have a question on service, for example, every now and then you find that they didn't do a good email or whatever, we'll postpone it. But other than that, there is no such thing as a default. So occasionally I've had people either say to me, I can do it on docs only, and I'm okay with that. And sometimes I have one, they want to come in and they want to put their witnesses on the stand. It may be, okay, that they think it's going to come out better and maybe want the opportunity for me to ask questions. It's their process. They want to come in and do it one-sided, I'll let them.
Sure.
I've had one of these long while back, and just some food for thought. You cannot you have to get an arbitration award to turn into a judgment. So you have to have either a hearing or a documents only kind of ruling. But just for logistics, what we ended up doing was that the arbitrator said, hey, we can still keep the hearing, but somebody's going to pay my fees. And so we had to pick up the other side's fees just to make sure it wasn't unfair to the arbiter to essentially work for half of what he had been promised. And then we put on our case and got an award and got a judgment and went forward like that. But just a kind of warning to potential parties out there, that's something you should consider.
Yeah, and
Absolutely.
can I add on that for one thing? So, because an issue came up in a case recently where one side, guess which side, didn't want to pay half the fee.
No, sometimes it's the claimant.
Yeah, well, sometimes yes, but this one, it was clearly the other, so it was the respondent. And the question got raised of what were we going to do or not do? In one instance, the claimant picked up the other fee, but in the other one, we sort of said to them, you have an opportunity, but you've got to pay the full fee. And somebody said, well, that's unfair. Or does it look like the claimant is buying our decision? And my answer was this: no, for 2 reasons. Our decisions are our decisions, okay? But if someone would be able to prevent a result in arbitration by not paying the fee, then it would be very simple to say, I've agreed to arbitration. Guess what? I won't pay the arbitrator's fee. Ha ha, you can't get a judgment. I mean, that's inherently unfair.
It's a
So
weapon.
right, it's a weapon. So if you were basically to say we won't go forward unless both sides equally pay it, you're weaponizing the respondent, excuse me, to preclude getting a judgment.
Sure. So Leslie, one more for you before I turn to Beyonce.
Okay, same thing sort
Waiver
of
of
said.
oral hearing.
Yeah, it's a waiver of oral hearings. It's the same thing. It's asked for document submission. And by the way, just 2 seconds. Arbitrators have the right. So when I'm done getting my evidence in, so usually this happens in docs only cases, I have to look at it, and sometimes it's after hearings in post arbitration hearings. I'll look at post-hearing briefs, but before the award time starts ticking, I have to what's called close the hearing. On occasion, I go back to people and say, hey, you didn't answer this question, or you've raised something in post-hearing, show me where it is in the record. I have one where they've submitted, the other side hasn't appeared, it's docs only, they've asked for relief, and I literally went back and said to them, through the AAA, I don't see a client, I have nothing to link your contract to the dollar amount that you want. You've got to walk me through your contract because I've read it and I can't figure it out. Get me a client attestation. And they have literally not given us anything. And I'm going, well, you're going to get a denial because I'm not, just because you say you sent an invoice doesn't mean that that's a legitimate invoice. That to me is not, that's evidence.
Sure.
It's just not dispositive evidence if I can't figure out how you calculated it from your contract.
Absolutely.
So I think people need to pay attention to that.
Absolutely.
I think this is me again.
This was Liz's part, but I think you can do this in your sleep.
I can handle it.
I think he's good.
I think you guys can handle any of these slides.
Yeah, I can handle the full disclosure. I've never had to object to an arbitrator other than at the disclosure process.
Okay.
And so the timing of objections always earlier. And let me make sure we are all on the same page of what we're talking about for the audience. Objections to the arbitrating mean we don't want this person. There's something wrong with this person who's going to preside over arbitration. Okay, and disclosures. The sooner you object, the better. Only because you're just adding further costs. You can try to eliminate an arbitration award based on the conduct of an arbitrator. And some statutes recognize that. However, you've already paid all this money to get an arbitration award, get through hearings. So do it early.
So you're 100% correct. So two things, let me add to that. Where it comes up, I'm very robust in my disclosures. It's not unique to me. And my conflicts that I run are very different than I do in other cases because for disclosure purposes, when I say conflict, it's not really a conflict, but it's a conflict check. So for example, I will disclose that the claimant in the matter has been before me on other matters. I don't disclose the other party because I can't. The attorneys have appeared before me because if somebody thinks that they've been before me 6 times and I'm their guy or gal, they need to know that they should make an informed decision. So I will disclose that I will run witnesses' names. So it's an ongoing obligation. So I have a case where the hearing is next week. We got witnesses' names. I ran all the witnesses' names. There was no disclosure. And I told them there's no disclosure here. But every now and then something can pop and I have to say to the parties, hey, I know someone at that law firm. Some of the things I have a generic one for LinkedIn because I'm like, I'm not checking my LinkedIn. I have 5,000 people. I have no idea if they're on it or not. And sometimes, I'll say, and I used to do it, but I don't do organizations. So beyond Sook, I mean, you and I have a relationship as friends, right? It'd be different. But let's say we just knew each other from the ABA. I'm not running that. I'm not saying that. How many people are members of bar associations?
Yes.
Right.
So I tell people I don't do that. But I might say sometimes if it sticks out enough, we've done a panel together.
That's right. And I've had arbitrators also disclose, hey, I've never done a case with Byung-Suk, but his law firm has had several NAVs in the past, stuff like that. So,
I'm sorry, go ahead.
No, I was going to say, just object. And if the AAA is running the program, they're great. You object and raise it to them and they help you deal with objections. And if you have to find a new arbitrator, they'll do it. So that's great. Absolutely. You can do it at the hearing as well. But hopefully you by that time you've invested a lot of money. Hopefully you've worked out the objections. But again, and typically the objections you would consider at a hearing are either one, what Leslie mentioned, a failure to disclose a witness kind of relationship, or basically really bad behavior by the arbitrator that's preventing justice from being served. So that's rare.
The only other one that I will add, and Jeff, the book is just coming out. It's being published. It was a book off an ethics panel that I spoke and wrote on. There are cases where the award comes out, one party loses. And there is an egregious case. I can't think of the name off the top of my head. Maybe Jeff remembers it. But this was egregious, where they looked back and somehow they figured out that the arbitrator had not made a disclosure. And it was essentially something to do with one of the attorneys had been at a firm that they were, it was enough that it really was a raising of the eyebrow, like, why would you have not? And they'd been before them and they'd been on another case with them. It was several steps in. It was enough. And the party said, you know, I lost, and I don't know if I lost it because they've got 6 degrees of separation that they never told me about. And it was vacated because it was enough to taint the process. I'm not saying that arbitrator did what they're afraid they did. And obviously the losing party had an axe to grind. Had they won, they would never have done it. But the view I always have of if it's really a nothing burger, it's better a nothing burger at the outset. It's a something burger at the end.
No, and you're absolutely right, and I agree with everything both of you said. But we at AAA, as you guys know, we always say disclose, disclose, disclose. And you know, we also Beyonce, thank you for saying that we handle these issues properly. We have an administrative review council that meets every Tuesday with executives from the AAA that review disclosures and make a decision on whether or not the person should be removed. But we say the same thing at AAA to the arbitrators: make sure it has to be right at the beginning, and your objection has to be at the beginning. And we see, you know, I'll remove an arbitrator from the AAA's panel if he or she is not making proper disclosures, and we run into issues with that. So, Beyonce, I'm going to stay with you. Settlement negotiations at hearings. We like to hear this at AAA.
Yeah, you bet. But before we do that, I just want to talk about issues with arbitration when you don't have a good administrative organization,
that's right.
or
Sorry.
the provisions are terrible. Yeah. If your arbitration provision is blank and you get past the disclosure phase, all of a sudden you realize this arbitrator is not doing right. And if you did, what I would recommend parties to do is fully disclose to the arbitrator your concerns. If they don't voluntarily leave, but you think you have some concerns, confer with the other side, have references to your local laws on when you can disqualify or when you can vacate an award due to something related to the arbitrator, and use that as kind of a discussion tool with opposing party and counsel. And typically, if you have a legitimate and serious concern, they are going to be savvy to the fact that, oh, why do I want to give Byung-suk the opportunity to undo an award?
Right.
And so again, full disclosure early and often. And when there is no administrative procedure know your local laws regarding arbitration awards and when they can be vacated due to issues related to the arbitrator. But when it comes to settlement negotiations.
Oh, yeah, okay. I just give one more quick thing on this.
Yeah, you bet.
On the ad hoc thing, we know we do have a service at AAA ICDR where we can review non-AAA cases about removal of the arbitrator. So just realize that the institutions have that, and it's something that you should use if you do ad hoc. Ad hoc can be dangerous. So Beyonce, settlement negotiations at hearing.
Yeah, basically, you can. I say this all the time to clients, and they're just shocked. They think there's only one opportunity to settle, and that's never true. You can settle at any phase of arbitration and trial, quite frankly. So you should know that, and that's true in arbitration. So you can settle partially, you can settle full anytime before the arbitrator renders a final award. But you can also settle afterwards based on the final award. Let's say, let's create a scenario. Let's say my client has been hit with an award of $1 billion. We can literally go to the other side and say, hey, we can only pay $500 million over 2 years. Can we just settle on that amount? And maybe the other side believes that and does that. So don't believe, obviously, that arbitration award is going to dictate how you settle afterwards. So settling before is encouraged. The second bullet, and I know, is that arbitrators should not participate as mediators because they already have some partiality based on the proceedings, or if you're in the middle of the hearing, based on what they've seen. Now, I know Leslie and Jeff are going to cringe, but I'm kind of open to it under the right circumstance. I haven't seen it yet, but I'm open to it.
Wait. I'm not going to cringe. It depends on what we're doing. Go ahead. I'll tell you what.
I'll leave it at that. So if you guys want to chime in on that and react to that, please do.
Well, historically, AAA has been against bullet number 2. Agrees with bullet number 2. But now we're kind of shifting, and there's people in our community, as Leslie knows, in the New York community, that are kind of embracing it a little bit because they say it depends if the clients really feel comfortable. That's Leslie?
So here's my view, and there's two thoughts. If you had, in my view, you can't do meet arb. I don't believe in that at all. So if I've been a mediator and then they want me to become an arbitrator, okay, I can't. The curtains have been opened. I can never, because they'll attack the award. Okay.
But
If
even
I've
if it
been in-
was, even if you did it all, no caucusing, okay, got it.
because they're still sharing. I don't like it. They're still sharing stuff that they might not share, and someone's going to use it against you. I really don't. There's no way to effectively mediate with no caucus. It just really isn't. I don't think. And you've taken off your hat and you've taken down the veil. If I'm an arbitrator, and at some point in the process they want me to mediate, as long as the arbitration is left behind, I don't have a problem with that. If they're like, you know what, we think we can get this done. You've heard the facts. We're really close. We're not going to go back and ask you for a decision. If you're clear, you're not going to ask me for a decision and you want me to take the walls down, I'm good with that, because to me, there's no harm, because I never have to worry about it, because then I'm not making a decision. There's nothing to attack, and people are doing it of their own volition. So that's the it depends for me. But there are some people who believe that you can arbitrate to mediate to back to arbitrate. And they'll let people waive stuff. And I said, until the decision comes down against them, and they're going to say, you know why they did that? They did that because Byung-suk told her something in private caucus, and she knew X, Y, and Z, and that waiver's worth garbage. And I will never put myself in that position. So I will not do that. That's my it depends. So I cringe at that. But other than that, Byung-suk, it's not necessarily off the table.
Yeah,
And it
like I
seems that
said,
I don't have
you
strong
seem that-
feelings about this, just to be clear.
yeah.
it seems like you have some feelings about this that you I think it's
I,
okay.
I do. And there are, if you know your case and you're in the hearing and you have a good arbitrator, and all of a sudden the parties want to mediate, with few, I am not going to change my presentation that much if the mediation fails. What is going to happen is my assumption is going to be, and of course the parties have to feel comfortable, is that if Leslie is mediating with us, I'm sharing information and she's sharing information, because I know there's a risk of going back to arbitration. Not that I would ever mislead our mediator anyways, but I'm assuming the other side knows, okay, if I'm telling Leslie that we got a witness that's going to say A, B, and C,
Yeah.
and there's a chance the mediation doesn't fail, I think that keeps the attorneys and the parties a little closer to what they believe is the truth. Okay. And so I'm less concerned about going back. To me, I kind of believe in certain situations, you need the risk of going back to arbitration to keep the mediation pure. And that's why I say I like it. And another thing is, if I've always felt good about the facts and the law on my side, and I felt like my clients just put on a great show at the hearing, and I have some great witnesses coming up, I have no problems with going back. Obviously you have to do the right disclosures of risks, upsides and downsides with the client. But that's why I'm a little more open to it, because I also don't want to re-educate a new arbitrator.
Yeah.
I want to go in with the arbitrator that has history with us and can understand. And quite frankly, if I'm being over the top and pulling out BS all the time during mediation, and I can't deliver during the arbitration hearing, I deserve it. I deserve whatever ruling I'm going to get, because then Leslie is going, Byung-suk, you said this. That didn't turn out to be true.
What about Byung-suk? What about consent award?
Yeah, so the consent award is interesting. I've dealt with consent decrees in court, not consent awards. I just don't run into them very often. But the concept is essentially the same. You can reach an agreement and then basically have the arbitrator adopt the agreement if it's acceptable to the arbitrator, and it turns into an arbitration award. Thereafter, you can do the same thing with that arbitration award, a consent award that you can do with any arbitration award, meaning depending on the terms of the settlement that's incorporated into the arbitration consent award, you can turn that into a judgment. Okay. Sure. And what happens is then you not only do you essentially have a great settlement agreement, but you have if somebody breaches that settlement agreement that's embodied in the consent award, you have the potential of seeking contempt or seeking a ruling from court if you require action to force somebody to do something because they violated the consent award. So, I'm assuming on settlement terms that aren't just financial, that's when you would typically use the consent award or consider the consent award, because you have the stick or the threat of a court coming down on you saying you've just violated a court order by not promising to issue me financials every quarter, something like
Sure.
that. You know,
Sure.
I would strongly encourage the parties that if you're going to do a consent award, definitely iron out every detail you think that could be a dispute going forward and make sure it's satisfactory to everybody.
That makes complete sense. Okay, Byung-Suk, staying with you on post-hearing submissions. Now we're getting to
Yeah.
the post-hearing phase.
Yeah, and so there are several reasons why an arbitrator can keep basically keep the hearing open, quote unquote. I'm saying that because you're typically not in the hearing, but the arbitrator is essentially saying, I'm willing to consider more things for the next whatever. And you guys, and it can be presented in such format. You want to do this by agreement, obviously. That's preferable. But typically, in my experience, the great majority of when submissions are left open is to allow for closing offer basically closing statements that's supported by facts, or proposed findings and facts and conclusions of law, or proposed arbitration award. So each side, the way I've done it in the past is each side just presents, hey, I think the arbitrator should award issue an award in my client's favor, and here are the reasons why. And I cite two exhibits. Very rarely have I put in, I'm trying to think, I don't think I've ever put in any new document or testimony that wasn't already presented at the hearing. But depending on the situation, if new matters arise and you want to open up the hearing and it's not
Sure.
allowed, you may want to consider submitting it with kind of the post-hearing submissions to see if the arbitrator is going to do that. And we typically, as the slide kind of suggests, we typically allow for 30 days to do that. Yeah, and typically now it's a multiple of 7, so 30 days is dating us.
Okay, so Leslie, I'm turning to you, declaring the hearings closed.
Right. So two seconds. I just want to highlight something. So again,
Let me go
I
back.
noted earlier that I can go back and so AAA. No, you're fine on where you are, but
Okay.
I just meant I'm gonna go backwards myself in terms of recapturing something.
Got it.
When the AAA will remind me or ask me, hey, do you want to close the hearing? It is really prudent, to the extent there are arbitrators out there, do a quick eyeball, just quickly, go over what you got and make sure. Now, sometimes, once in a blue moon, I've had to reopen it because you can't, until you get into the weeds of a decision, you're like, oh gosh, they didn't give me anything on this, and you can't really see it. But I do really try to make that a very rare exception. Otherwise, once I close it, the rules depend. So generally in a consumer case, I think it's 14 calendar days. Commercial cases are a little longer. Now, sometimes it's, if I have several weeks of hearings and I'm going to have post-hearing briefs, I can guarantee you I'm going to say to the parties, and it's a tripartite panel, we are going to say to them, we can't do this in 30 days. You don't want us doing this in 30 days. Now, we don't want to be ridiculous, but we might say 60 days. And on occasion, I've had parties ask for adjournments of post-hearing briefs, and they come out with the schedule. I'm like, that's delightful. I'm on vacation for a week. I'm fine with that. Or you've put me in the middle of Christmas. Can you will you please consent to not have me? And it's sort of a work in progress. You try and adhere as close to the time frame as possible. But again, the magnitude of a case, you gotta ask for extra time. And the parties usually will recognize that you've done 2 weeks of hearings, huge post-hearing briefs. 30 days is just not enough time for 3 people to get together and render an award.
Without a doubt, yes.
Yeah.
Okay, so reopening of hearings.
There you go. So it's my request for additional information. Like I said, I try to avoid having to do it, but on occasion I've gotten into a decision and been like, now that I've thought through everything, this piece just isn't there. And sometimes a post-hearing brief will come. So the only time I could see a party asking to submit additional evidence is you've had post-hearing briefings and they have realized that something didn't make it in. And as long as there's no objection, and by the way, one of the things that I do, for whatever it's worth, this is how I view things. so if the parties will, let's say have 100 exhibits that are in the exhibit binders or flash drive or whatever, and they believe they're going to pull from that for the hearing. Okay, I don't read exhibits ahead of time. I will read your operative document. So if the arbitration is a dispute over 2 contracts and 2, those I'm looking at because I really want to understand that. That's part of your claim. But the rest of it, I'm not, other than expert reports, different story. But what I will say at the outset of a hearing is this: if you do not touch an exhibit, okay, I'm not looking at it. So it's, again, the rules of evidence don't apply the same way. So you don't always have to do the full authentication. It may be something that's a little bit more hearsay. Now, by the way, again, goes to weight. I may let something in and then decide it's a piece of toilet paper, but it may still come in. If at the end, when you finished your hearing, before we close, please go back and look and let me know if you each think that, crud, we didn't let these 5 emails in. And unless there's an objection because they think there's testimony, if they say to me, we really need you to look at this discourse or this additional document, just tell me, I'll look at it. Because again, I don't need a witness to let it in. Other than that, I don't see a basis that you're in decision mode and somebody comes waving a piece of evidence. It really have to be significant, a smoking gun for me to reopen a hearing.
Sure. Okay, Leslie, I'm staying with you. The
The
award.
award.
Okay.
Okay, so, we covered this a little bit, I think, in our last one in terms of the following. Your claim, like your complaint, is your guidebook. And here's where you file that one boilerplate 2-sentence claim and you don't put an actual claim before me. I don't know what the heck you're proving. But at the end of the day, I'm going to look through, and if you have 5 effective causes of action in a counterclaim, I need to address all of them. Even if it's one of them was granted, the other one is moot. Sometimes I will go and say, even though I think it's moot, and for argument's sake, I will issue a smaller piece. I'll say, they proved the breach of contract. I'm making this up, and just enrichment is not the right one, but some other parallel cause of action. A finding could be had under this. We've already established that. I won't get into it, but the evidence appears to weigh. So that if there's a problem with the first one, I've at least left somebody on vacatur or something like that with an understanding of the second. The other thing is that I think sometimes people get lost in the sauce and forget there's a counterclaim, like that they're advancing it or that they had to respond to it. I just don't understand how that got missed. And then the other thing is costs and fees. So because awarding costs and fees is no different than it is in court, where you need to do quantification and justification, I will often say to people as follows: deal with the liability or the responsibility. So in other words, is someone liable for fees and costs? Let me determine that. And if I find they're liable for fees and costs, then you can get me, I'll give you X number of days and you can submit, and they'll oppose whatever the documentation is. But I don't need, and it's one thing in a small case where they've done 10, 15 hours, it's a nothing. But in a major set of hearings, for somebody to do a fee request could be really a significant amount of time. Why do that if I may find that you don't have a basis to get your fees and costs? So again, I'm trying to be mindful of that. And the last piece of it is, directing people. We have the American rule. Generally, people bear their own costs. An underlying agreement may modify that and require that it's a prevailing party piece, so they can modify it by agreement. There are some statutes and some theories out there where you have a prevailing party. The other thing is there are provisions under various rules that'll say something like this, and I'm paraphrasing, I don't have it in front of me. If someone has basically brought a frivolous action, in other words, if you have and you see it in consumer, a lot you see it in consumer, but I've seen it in commercial, and I've had requests. This was a frivolous claim. There's no way in the world they ever could have thought that they had a claim under this statute or under this theory. Or my favorite was, this was commercial. They lost, therefore we should get fees because clearly you thought it was frivolous. And my response to that was, no. They didn't sustain their burden of proof, and were not successful in proving to me their claim. That did not make their claim frivolous. It might have, but not in that context. Still me?
Yep, it's gonna
Okay,
cover different types of awards,
perfect.
yes.
So a simple award is really he wins, she loses, he wins. Um, a brief reasoned is, let me give you the 6 reasons why and what I saw. And a full reasoned is, and I know I'm going to leave time because I know Björn has views on this and it's important to hear it. A full reasoned is, I'm going to go through the evidence. I'm going to go through the reports. I am going to go ahead and tell you why I did what I did. Bear in mind when I'm dealing with case law, and this is disappointing because I have left hearings where I know what the parties' claims are, and I have said to them, please, in your submissions to me, kindly brief. You want me to, for argument's sake, go outside the 4 corners of a contract. I need you to brief that issue because I can't do research. I'm not allowed. I can look at the cases you cite. I can look at the cases and the treatises cited in those cases because to me that's fair game. But if you don't give me the right law, that's what I got. I'm trusting both of you to get me what I need. And if you don't give it to me, that's where it is. The last thing I'll say on this is I tend to not do even if somebody says simple, I just still do concise. I just am never feel good telling someone they lost. So it still may only be 3 pages and it may say, they breached the contract. Here's how I got to the total number here, the total number there, and this here, because just saying you win and you lose, it just doesn't sit right with me. If somebody's walking away as the losing side, they should have some level of comprehension. And so it may not be the quite brief reasoned, but it's pretty darn close to it.
Absolutely.
Yeah,
Beyonce, you want to comment?
yeah,
Yeah, let
yeah, I
him
did.
comment before I do how we get there.
Yeah, I just wanted to share kind of some rationales for these different awards from the party perspective. And let me tell you, I've done, I think, a great majority of the brief reasoned, a few fully reasoned. We call them findings of fact, conclusions of law, and no simple. But let me tell you where you can push for the simple. If the arbitration award and the claims for relief were very narrow, let's say just a breach, it's basically just an accounting exercise of how much somebody owes somebody, and I want to shut down appeals, I would push for a simple. Not that even if you have any of the other types of awards, an appeal is easy, but it's even harder when you just get a simple award. You got to find other reasons than the award to try to appeal or overturn it. So we usually end up on the brief reasoned, or we just call it reasoned. And the fully reasoned is typically asked for by the parties that are concerned that they have an appellate issue. And so they want something to support an appeal. So that's where I see it the most. Most people don't want the cost associated and the delay, typically, that you have to provide reasonable time for an arbitrator. Depending on the number of claims and counterclaims, the arbitrator could reasonably ask for more than 60 days if it's a huge arbitration. So I don't usually want that unless I think there's a good appellate issue. And frankly, I've only seen it from the other side. And even then, when we received an award that was a little disappointing, we didn't appeal because we walked through the appellate issues and I said, most likely we're going to lose on all of these grounds. But brief reasoned is where we greatly center on. But I wanted to share some tactical considerations.
Yeah, that's important. Jeff, on the next slide, I can do this quick,
Sure.
which is how do you decide which one? In the absence of an agreement of the parties, either the agreement itself or the parties agreeing to change the agreement, the rules are going to control. It's as simple as that. And Björn already addressed the appeal concerns.
Yep, got it. Okay, Björn, I'm going to you for challenging and appealing the award. We have about 5 minutes left.
Yeah. So
speed round.
That's I'm not even going to look at this. I'm just going to kind of summarize it.
Sure.
Start with one simple sentence. If you're expecting appellate rights like you do in court, you are in the wrong forum. I've appealed only a handful of arbitration awards, and I'm 0 for that handful. And we fully expected it, but the client really pushed for it. And quite frankly, and if you look back on it, the client would understand that basically the arbitration award was probably rational. and support it. So there are essentially there are two things you can do in arbitration award, and you got to look at the local statutes. And most local statutes regarding arbitration awards provide certain limited circumstances to vacate an award, and certain limited circumstances to modify them. Let me attack the second one. To modify an award is typically clerical mistake. Let's say all of a sudden there's a miscomputation on interest calculation. Yeah, and typically I would just send a letter to the arbitrator on the opposing side saying, can you issue a modified arbitration award and see if we can resolve that way. But if it wasn't resolved then, but you go to court, you can have the court address it as well. The vacating award is tougher, but it's typically related to something the arbitrator did, where it basically either exceeded the arbitrator's powers, or the matter wasn't even subject to arbitration, but there was a poor ruling before, and so the court can vacate that, saying this whole dispute wasn't subject to arbitration. Rare, as you can imagine, if you're trying to file this in court to try to vacate an award, you've probably lost at previous stages, and you're most likely going to lose again. The other thing is if the arbitration was somehow stained with corruption, fraud, or some other undue influence, or if the arbitrator doesn't allow you to present your case. This is why most arbitrators allow everything in and say, I'm going to consider it, give everything an appropriate way. But that's generally it. I can go through more details, but given the time left, I don't think that's necessary.
Sure. A little bit on enforcement. I think you kind of covered it.
Yeah, enforcement, it's easy. You file a motion with the court to turn it into a judgment, and then you treat it like any other judgment. If you have a monetary judgment, essentially a monetary award, you turn it into a monetary judgment, and you start collections just like that.
Right. Okay, so we have a few more minutes for key takeaways. You guys can just both handle these. You tell me which ones you like, and you talk about it.
Let me jump on one. So I think one of the overarching themes is, do me a favor, do everybody a favor. If your dispute resolution professionals and advocates could get to your corporate folks and talk about a clause that makes sense, it would really solve half the world's problems that we talk about. Really, think it through. AAA has Clause Builder. It's great. It's a great way to plug in, some of your needs and concerns and at least get something to work from. And it's not like using AI where it's bad AI, but it'll help you as you spot and think about things. But, when people think about this and ask for a clause, like, just send us a dispute resolution clause. I'm like, okay, would you like to tell me anything about it? Who's going to win? Who's going to lose? Who wants to enforce? Are we going to be on which side? What's the nature of it? Do we need a technical person? All of those things count.
Yeah, absolutely. Yeah. Okay. I'll move to the next slide, which has some other ones. Anything pop out to you guys?
Jens, do you want to add anything, or do you want me to?
Yeah, I think all these are great bullet points. I am not a big fan of three arbitrator panels. I feel like they add a lot of cost, and it just takes time. And it's not criticism on the arbitrators, but it's just a natural outcome of three people trying to schedule their busy lives to issue a ruling. So I'm not a big fan of that, but
even for the hearing itself to do it is very, very difficult.
Yeah,
that's
takes
right.
6 months. It takes 6 months longer with a tribunal, and about 5 times more in cost.
Yeah,
such as you're alluding to.
And one highlight, we talked about your clause. Maybe at the outset you really thought 3 was the way to go, but maybe the nature of this dispute that flowed from the agreement doesn't warrant it. You can change it by agreement. Please
Absolutely.
think about that. I've sat on 3-part panels that make no sense given the cost, and nobody will do it, and we can't do it. The only way we can mitigate it a little bit is sometimes if you're chair and say, tell you what, it will bifurcate it, which is basically the chair will run discovery, bringing the others in as necessary, and then the rest step in for the hearing. It's an option to reduce it if you think you want 3 people in the room to sort of hedge your bets. That's another thought.
Great.
Yeah, and just another suggestion to your point, just because the arbitration provision says one thing, the parties cannot simply agree to amend it verbally or by joint agreement. And I've been pushing this in certain situations when it's a purely accounting matter. Let's say, oh, I was the way that whatever payment to me was calculated appears to be off. Yeah. And under those kind of limited scenarios, I've actually pushed for, hey, let's just use a accountant. If we can all agree on the proper accounting method and the factors that should go into it, let's just send it to an accountant and I'll agree that whatever he decides, we accept.
Sure.
And so, you know, the party should be creative as much as possible. Don't be unnecessarily bound by our ADR provision, but hopefully you have a good ADR provisions just in case you can't reach an agreement.
Absolutely. I like this last one. Remember, this is arbitration, not litigation. I stress that all the time. We're out of time, guys, but I want to, you know, first of all, thank you guys. You guys are terrific as always. Okay. And
Thank
this
you,
is,
Jeff.
this
Same
concludes our
time next year.
Yeah, same time next year. This concludes our webinar. Thank you for joining another entertaining yet educational production of Financial Poise. Look for Financial Poise webinars wherever better continuing education webinars are sold. And we hope you will join us for next year when we do this again. This is the last one in our series of 4. But thank you guys again. You guys are.
Thank you, everybody. Been such
Thanks all.
pleasure. Jeff, I'll see you soon. Take care, guys.
Always a pleasure,
Thank you,
guys.
everybody.